Perfect. Ladies and gentlemen, welcome to the Zoning Board of Appeals of Rockport, Maine. It is November 29th, and we have everybody here, which is great. Last meeting we had, this is just an update of where we are and where we're going. Last meeting, we heard public comment, and we had heard presentations from each party. Then the board got into initial deliberations and quickly came to the conclusion that our toolbox was a bit light. Our duty in these proceedings is to review the actions of the planning board to see whether the planning board's decisions were within the scope of their authority and supported by substantial evidence in the record. Without the legal document known as the findings of fact, we had nowhere to go, so the meeting was continued until tonight. So thank you all for your patience. Picking up where we left off, it's important to understand that, one, we're done with public input. That was wrapped up at the last meeting. We will acknowledge that we got some letters thereafter, which were not put into the public domain, but were heartfelt letters. There will be no additional presentations from either the applicants nor the appellants, except that the board may ask qualifying or clarifying questions from either party as necessary. At the last meeting, the board had some discussion about whether Mr. Murray was officially asked and to be serving as counsel for the two people that remained on the official list as appellants because of their adjacency to the property. By virtue of two letters from the Calorans dated October 24th, we understand that Mr. Murray is officially representing his neighbors. So our job tonight is to look at the record and to determine whether the planning board made their decisions within their purview and based on the record. We are not here to interject our opinions of the project, nor to re-adjudicate the application. If we find any instances where the planning board stepped outside of their bounds or acted without sufficient evidence, then our action would be to force the planning board to revisit parts of their decision. If we find that the planning board adhered to its mandate, then the appellants can exercise, and then this part of it would not go to the appellant's way. The appellants could exercise their option to take our ruling to Superior Court, who, if the case is accepted, will make a ruling drawing on the finished findings of facts, both from the planning board and from the zoning board. So that's where we're at. Any questions from those folks on the other side of the dais? So we are starting our deliberations. And I propose that we use as a roadmap the appeal itself, and we'll just go through the appeal and hit every aspect of that and go back and forth between the appeal and the findings of fact to see if the planning board had sufficient evidence to make a decision and were within their purview. All right, first one is primarily the biggest thing that they spoke about. I'm not going to read it verbatim, but the essence is, well, that's an introduction. So first one is titled, "The Board Improperly Deferred to the Owner's Characterizations of the Proposed Use." So in this, this is section B on page 4. And this particular argument does not really say that that they made the wrong decision. It was just an observation that in their opinion, there was things written on early in the process that were not brought back into play later on. So this goes on for 2.5 pages, this particular thing. Does anybody want to characterize their complaint differently than I have? Or make any observations on the complaint, and then we'll discuss what it is we do with this, because it's not really they got it wrong here. It's just more of a process thing, it seems to me. And it,
Well, in essence, the argument is that the planning board didn't make its own decision as to proper use, that they simply deferred to the applicants.
right,
That they made no independent decision on their own. That's what the allegation is. And that in fact, they should have made a finding that it was congregate housing as opposed to residential multifamily and office professional.
as shown in page 6 in the middle.
Right.
Yeah. So we get into congregate housing again in C.
Right.
So let's look at this first part of the complaint and mine it for any of its value, with everything except the congregate platform. Yes, please.
So are we still on B?
We're still on B, and we're trying to kind of, in a sense, figure out what to do
Is
with
it
B.
the moment for me to say when I compare the allegations in B to the actual, now we have the actual official findings of fact, it's clear to me that whatever, in spite of whatever initial, this always happens, the argument over vocabulary and word and concept, and those can be valid. But it's really clear when you see the scope of review that the planning board did, that I wouldn't call them that they deferred to the owner's characterization. I mean, to me, they properly dove into the ordinances, compared all of everything from the plans to the written words to the visuals to the site plan, and concluded, I don't think that they were overly driven or that they took any shortcuts or just said, oh yeah, okay. Or that these particular weaknesses that the appellants point out were really at all significant or material in driving them and, or causing them to overlook or take shortcuts. I just don't see that at all. I think they did a thorough job. So I don't find this particular complaint to be credibly supported.
Anybody else's observation?
Jeff, question. I don't have a date on the zoning board of appeals application. It shows the signature of the appellant, but there's no date on this. I just want to make sure.
Show me the first. Yeah, that is part of the document we're looking at. No date received by planning. Orion, you want to address?
Yeah, it was received in the correct time frame.
timely
We're
manner.
currently in the process of updating our applications for everything process, so that
Yeah.
there's an appropriate.
I just want to make
timestamp.
sure, because we're looking at this and then we're looking back
Yeah.
at the actual meeting, okay, of the planning board, which is May 26th.
Right.
So we're comparing information here coming from the appellant to, again, what the
Right.
planning board already made decisions on, including, again, the zoning district review.
Yeah, well, and it's part of their argument. What I have a problem with on B is that it's just kind of like, well, you said it was gonna be like this, and then we never heard about that again. And it's like, okay, it's been entered into the documents. But I see B as kind of a generalized, that the developer, I hesitate to call that, but the
But Jeff,
characterized the operation in a certain way and then didn't reinforce that
I mean,
later.
specifically again, the planning board on their May, again, 26th meeting,
Yep,
in the zoning district review, they're very clear on what they're saying. So I'm not, how we can even go there.
Yeah, plus
that's my same question, yeah.
one person's deferral is another person's agreement. I mean, the applicant came forth with a characterization of what the proper use was, and the planning board seemed to agree.
So, Terry, who's had the benefit of several years on the planning board as well, finds that as a general, correct me if I'm phrasing this wrong, but as a general strategy that the planning board upheld their end of the bargain with thoroughness and appropriate action.
Right, I'm saying I think this is not true, that the planning board improperly deferred. I don't see that. Whatever happened early on, or whatever confusions in terms of vocabulary, whatever, I read the finding of facts, and they simply went forth and did their job with all of the material presented to them, including non-verbal things such as plans and comparing to the ordinance. And I do not see any evidence of improper deferral or shortcuts or overlooking or things not tended to properly. I thought it was very thorough.
Do you want to, at the bottom of page 6, paragraph that starts, therefore, to the extent that the board approved any portion of the facility based on a characterization that it would be used for professional offices, the decision is plainly wrong and contrary to the owner's own representations. Having been on the planning board, do you want to speak at all about the task of fitting something into a preordained structure? The appellants are saying they took the information they had and they put it into professional offices. The appellant thinks that's wrong. The planning board thinks it's right. Would it be helpful for us to understand from the planning board's perspective the task at hand when you try to say, is this a zebra or is this a horse?
So, if I can, I
Yes,
don't,
sir.
I think that question is better directed to me.
Very good.
So the planning board, in terms of the application, the applicant puts forward their application, they say, my use is X. They'll get approved or denied based on that, not you should be over here. Now, in a pre-application meeting, they could say, we're thinking this is where we're at, do you kind of agree? And then move forward on that aspect of it. But in terms of the final application, they put forward a final application based on a certain use, and then they would get approved or denied based on that use.
Okay, thank you. So any other comments, observations, challenges to section B, improperly deferred to the owner's characterizations of the proposed use?
No.
Ryan, I imagine that what we would do is we would vote on each one of these
Yes.
issues singly and then combine. I await a motion on our observations or ruling.
Jeff?
Terry.
I move that the planning board did not improperly defer to the owner's characterization of the proposed use.
And a second.
Second.
Okay. Any
Did not defer.
discussion on the
Affirmative.
motion? It's been a while. I think we
Just
discussed
thinking
it
if
out.
that was a double negative.
Starting down there.
Yes.
Bill, yes.
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 Yes?
Yes.
Terry.
Yes.
Okay. That is by 6-0. Moving on to section C, their claim is the proposed use is in fact congregate housing. I spent a little bit of time today reviewing both the meetings of the planning board and the zoning board. And the congregate housing was the thing that was most discussed by the appellants. Anybody want to dive in?
I know you don't want to skip the next section, Jeff, but D is the same thing, I believe. I mean, it's the same question we had before.
Yeah.
I just don't understand, and being a new member of this board, I have to ask these questions here, not in private, so excuse the dumb questions. At the bottom of page 8, it states, at the same time, a determination that this use is congregate housing is not essential to a decision that the project cannot be approved as presented. What is essential is a finding that this is not a permitted use in District 907, since the board approved the project as such a use. Did the planning board approve it as congregate housing?
No.
Well, how?
No.
And it doesn't say so in their report in May. So how can that be a,
Right, and the
Statement.
findings of fact, but that's what was missing with those minutes, excuse me,
No, that's right.
Mr. Chair, if I
Please?
improperly jumped in. That's what was missing, as I recall from our last meeting. We didn't have that fully fleshed out findings of fact. It just had these sort of, fully meets section 900 of the, but we wanted to know the basis. And the finding of facts clearly spell out that their basis was, that it met the ordinance
Residential.
requirements.
So there was no other decision made by the planning board other
No.
than what's in page 6 in the
No,
zoning
they
review?
state it's on the basis of residential multifamily
Thank you,
with some mixed, corporate office.
thank you.
But if I could offer a comment,
Yes, please.
as a lawyer, I think this is lawyer speak. They're
Mhm.
saying that you don't have to find that it's congregate housing, you just have to find that it's not a permitted use in this district. Well, okay, fine. But the argument is it's properly congregate housing. That's the argument.
That's his primary argument that
Yeah.
he starts with, yes.
Yes. And congregate housing is not allowed in District
Mhm.
907.
Right.
But he
But we're
was
saying
right,
that's not
but
what they
it's got
approved.
that- They're saying
Because the finding of
that
fact
the
was for
board
multifamily.
approved the project as such a use, in other words, congregate housing, which
Right.
Yeah,
is not correct.
It's hard to understand what this means.
Yeah, it's
yeah.
kind of like a pretzel.
They approved it as multifamily,
They
residential
did.
multifamily, and office professional.
Right.
Right.
So the issue is whether it's best characterized as congregate housing, and again, our standard is whether or not the planning board made an error of law, abused its discretion, or made a finding not supported by substantial evidence.
Right.
So it's not whether,
It's not whether we think
Right.
it's one or the
Yeah.
other, it's, yeah.
not whether we would have done it differently, but whether they had substantial evidence to support their finding.
So, part C, proposed use is in fact congregate housing. Any other observations on that? And we find that the findings of facts support the professional office and the fact that they discussed it and considered it.
Residential multifamily.
Right.
Thank you.
I don't think they made an error. I think it's well within their discretion to make that conclusion. Whether others may debate it, it's one question, but they
Mhm.
had substantial evidence to reach that conclusion.
Okay, those are both points that we're looking at. Would you like to roll that into a motion?
I move that the Planning Board of Appeals deny the appeal on the congregate housing issue because the Planning Board did not make an error of law, abuse its discretion, or make a finding not supported by substantial evidence in the record. In finding that residential, multifamily, and office professional are the proper uses of this project, which are permitted by in District 907.
Any second?
Second.
Max? Any discussion on the motion? All right, going from this side, Terry?
Yes?
Yes.
Yes?
Yes.
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 Okay, 6-0. D, as you pointed out, it's basically the same as C. It doesn't really, well, let's go to B.
But let's do it.
D number 1 is reiterating what we just discussed. D number 2 deals with safety and security. Anybody want to comment on that? And actually, Terry, you commented on this in the last meeting.
I did, but are we finished with D? Did we wrap D and C all together in that last vote?
Well, I see, we go D and then we go Roman numeral 2, so I presume that
Right. but
safety and security is under D.
No.
Take it as a 2.
Safety and security
It's
is,
a whole new thing.
yeah.
Okay.
So in
It's
other
not
words,
listed
it's
like
section 1,
Cool.
C and D, now then safety and security is section 2.
So for purposes of
Thorough.
input thoroughness, does everybody agree that, this is not a vote, but by acknowledgement, does everybody agree that D, proposed use is not a permitted use, is essentially what we just discussed?
Yes.
I agree.
Okay. Moving on to big section 2, safety and security. Terry?
Hey, Jeff, if you don't mind, just for the record, can you put a motion together that states to such?
Absolutely. I entertain a motion on section D of the complaint. Who's feeling less than verbose?
Bob's ready.
You want to do?
So I move that we fold in section D into our previous motion concerning whether or not there was substantial evidence to support the decision of the planning board that congregate use was not the appropriate use for this district.
Any second?
Second.
Any discussion on the motion? I'm gonna ask you, from a lawyer's perspective, is it better just to make the statement that findings of facts negate this, or because you put a contingent on the previous action that we took
Just to fold the last motion into the previous
into the
one.
previous one?
We could restate this in a more compact and pretty fashion,
Okay,
if you'd like to do that.
but in your experience, here's the nub of it. In your experience, will this cause any consternation or bump in the road for the Superior Court? Phrasing it the way you did.
I don't think so. I think the Superior Court would be able to understand what we intended.
That we considered it to
What
say.
what we might consider is putting it into a more, taking the essence of our decision and putting it into a more accessible fashion.
So I suggest that we really treat D separately and zero in on again, what to my mind seems to be an error in this appeal, characterizing the proposed use as not a permitted use. It's very clear from and out of this, I think we'll get a simpler,
Okay,
if I could suggest a simpler vote. It's clear from the finding of facts that the proposed use is not congregate housing. It's true, proposed use as congregate housing would not be a permitted use, so they're kind of pretzeling in here. So I would rather say, the planning board, the proposed use was not congregate housing, so that's an error. I think that's where we're stumbling. So I think we should vote that, in regards to D, that we reject this portion of the appeal on the basis that the proposed use in as described in section D is in error.
okay.
Is that
So-
helpful?
Well, it is. So let's
Get
clarify
us a
what we're
little
doing here.
closer.
This is discussion on the motion.
Right,
And
Right.
if the second wants to retract the second, then the motion maker can pull the motion and we could go with something that specifically, as you say, since we're delineating these in the sections that they gave it to us, it feels safer to take D by itself, even if it's essentially the same as the
Yeah.
thing before it. So would you like to
I
retract?
will retract my second.
I will retract the motion.
And Terry, you want to form a new, more simpler nation?
I move that the zoning board of appeals, what do we say, rejects? Appellates,
Well, put it,
Complaint
if you put it in
B.
the positive, usually motions are in the positive, so you say, the zoning board did not err in their characterization of.
I think you mean the planning board.
Planning board. God, I always do that. Thank you.
but the problem here is that the appellant is in my opinion, mischaracterizing this proposed use, much like section C. It's pushing this idea that somehow there was this proposed use out there for congregate housing and it's not a permitted use. I just don't see that as ever happening, so I don't want to acknowledge. Okay, I move that the planning board, characterization of proposed use as residential multifamily with mixed professional office was a permitted use.
Was a correct.
Is a permitted use in conformance with the provisions of section 907.
Okay.
I'm trying to I'd like to just address.
Sure.
How do we turn that negative of they are mischaracterizing, in my opinion, what happened in the record. The planning board never, they
well,
reviewed all the uses.
so why don't we take all the pressure off in terms of anything that you might have said and say, how would you respond in a ruling to letter D, the proposed use is not a permitted use? Just take it fresh start on your wording.
The zoning board of appeals finds, just a moment,
Mhm.
I move that the zoning board of appeals finds that the planning board's determination that proposed use as a residential multifamily with mixed-use professional offices is a permitted use in section 907.
Did that make this go away?
And that such finding was supported by substantial evidence in the record. It was not an error of law or abuse of discretion.
What he said.
Orion?
Well, I'm writing on it.
Yep.
Just a correction, district, not section?
Yes.
District
Dis-
907, thank you. District 907.
We'll wait for Orion to do that and then see if we have any seconds.
Maybe he can read it aloud before we second.
I wouldn't be able to read it aloud.
Okay.
But if you're asking me if I see any issues with the motion made, no.
Okay,
Second.
second? All right. And voting from that end?
Yes.
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 Yes?
Yes.
Yes.
All right, 6-0. Now we're on Roman numeral 2. Safety and security.
Jeff,
Yes, sir.
can you tell me where in the land ordinances that is required?
Terry's gonna help you out on that, but you're right, that's one of
Yeah.
the first questions,
Mhm.
is,
Where is it?
well, it kind of really isn't.
It's not there. That's the point that I made at the last meeting, that safety and security, all of these issues that they raise, whether you feel they are valid or not, lie entirely outside the purview of the land use ordinance. And again, neither the planning board nor the zoning board of appeals or any board can, our authority only it does not extend outside the boundaries of what ordinances, there's not any safety and security. It only requests, the process requests for input from the fire chief and the police chief. They submitted their letters, they reviewed the project, they found no issues, therefore that part was
Mhm.
properly attended to by the proper authorities. That's not within our bounds of authority,
And rather, I wasn't picking on Terry, but
or planning board.
the last meeting, she
I wasn't
brought up the,
Obviously, I wasn't listening to the last meeting.
took care of that matter pretty
I
quick.
mean, Terry raises an excellent point. Secondarily, I mean, there's a theme going through here that, well, there are gonna be all these homeless people wandering around threatening our neighbors. Well, this is not a homeless center. This is a supported dwellings for working
Work-
class,
workplace
working
housing,
class
yeah.
people. This is not San
I
Francisco
did
on
make
the
that
streets.
statement too, that, reading all the letters, understanding where they're all coming from, they were, in my view, improperly conflating homeless shelter with what this is, which is a residential multifamily with, it's affordable housing. Affordable housing project is not the same as a homeless shelter. So again, you get into the weeds a little bit, like what was addressed in, C and D, that, well, these terms were used, and this happens all the time with zoning board of appeals and planning board, that the initial use of various words that mean different things to different people, even though you may get the gist of what people are trying to say. But when you get right down to it, technically, an affordable housing project is a very different animal than a homeless shelter, and this is clearly not a homeless shelter. So, That's what I said at the last meeting, though.
Where you
Whether it
obviously
was-
weren't.
That was beyond the bounds
You
of my
got now.
authority.
Now, this is not a basis of the appeal, so I don't know that we have to
Yeah.
rule on it.
I think we just find that it's not in the ordinance, and therefore the planning board,
Yeah, one could craft a motion that mentions that Chief Gagné
yeah,
responded to these issues. And my guess is, and totally an uneducated guess, is that is a better process for us to step
Right.
into rather than leaving it officially unaddressed.
so how about this? The zoning board of appeals, I move that the planning board properly executed its duties in receipt of review letters from the police and fire chief as to issues of safety and security with this project.
July 25th letter from Randy. Second on the motion?
Second?
Bob?
I just got a discussion.
Yeah,
I just
please.
wonder why we're even addressing it. I mean, it's not in our ordinances, why are we even
Right.
commenting on it? You know,
Only because I'm guessing, I would rather leave no stone
Okay.
unturned.
Right.
As I say, that was I'm neither a lawyer nor do I appear on TV as one.
It's for the avoidance of doubt, as the British say.
Thank you very much.
Okay.
We'll put that into the brief, as the British say. Any other discussion on the motion? Terry,
Yes,
voting.
Yes.
Jeff,
yes.
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 All right, 600. That comes to the end of our roadmap, which is to follow the appellant's complaint. Orion, should we have a total wrap-up vote?
Yes.
So this final vote would be a vote that declared our position
We're
of
deni-
the entire matter.
We're just denying the appeal, right?
Yes.
I know, but we have to, you brought up a good thing. This particular copy that we got, again, I don't wanna be a problem here, but how are we going to, we have to be able to describe it
To
when we
refer to it.
deny it, and usually we refer to a date and a description of party. I think we've gotta determine what that all is before we make a motion denying the appeal, cause we've got to describe it properly. Maybe Ryan can help us out with that?
Yeah.
Yeah.
I'm trying to find something real quick. This one.
I don't wanna table this for the
No,
next
no.
meeting.
There's another way of asking that question also,
Okay.
which is to say, is there any other documents from the appellant that could be confused with this one?
No, there's the original one, which was the placeholder, which is the notice of the appeal.
Right, single
That was
page.
the one that filed it, that held it. And then the formal application laying it all out that y'all just went through. So I think that the, to address it would just be, the consideration of the appeal for the Hope for the Future planning board application. To your point.
Do we have to describe the appellants? I mean, the only ones we had standing were the 2 killerins, or 3
Two.
killerins? 2 killerins? Do we have to describe them?
No,
in
because
the-
that was in this appeal, that was already determined that those two abutting properties had the standings, that's in the record. So in terms of this final motion, it would just be denoting that this appeal of the
Can
Hope for the
simply be
Future site.
described as the appeal, the Hope for the Future will do it, and that'll anchor it in space and time.
As best as we can, yes.
I didn't know there was much soil out in space to anchor. Anybody want to take that conundrum and tie it into a nice little pretzel ball?
Well, what I had put together previously was a motion to this effect. I move that the zoning board of appeals deny this appeal on the basis that, 1, the planning board did not consider the proper use characterization of the project, and 2, did not make an error of law, abuse its discretion, or make a finding not supported by substantial evidence in the record in finding that residential, multifamily, and office professional are proper uses of this project, which are permitted in District 907.
If this were a final, before we look for seconds, well, we can look for seconds if you want.
Second.
Okay, thank you. Discussion. I'll jump in for a second. And this is only because I grew up with lawyers, I'm not one myself. Do you, by mentioning at the very end just those 2 points, do you choke the description of the entire thing being, being not passed? Because there was a bunch of things in here that didn't rely on the 2 characterizations of professional offices and multifamily.
Do you mean the safety and security issue?
Yeah, I mean,
We could add a third point, a third basis, but again, it simply wasn't the point of appeal.
okay,
I think we've, in our record, every time we voted on those, discrete items, we made statements of finding of fact. So, to me, right now, we don't have to encapsulate all that, we just have to make that final statement of, acceptance or denial. So
Mhm.
I think just a simple, although I like, adding those last 2 phrases, cause we've often, it's been emphasized that those are important, but that what would precede it would be a simple, we move to deny the appeal of Hope for Future on the basis that the planning board sufficiently reviewed evidence, and then those little boilerplate, things that Bob added that we've been told are important to say, I think.
yeah,
That's the standard that the Superior Court would be looking at.
right.
Yeah, and that's been kinda drummed into us over the past few years.
So in your mind, Bob's characterization and wording is fine for our
Well,
final?
that we don't have to, that the first part of it, I would say, can just be much more simple. That we deny the appeal of the, Hope for the Future on the basis of, then just a simple statement that the planning board, the one that you seem to have memorized that I can't cough up right now.
Jeff, I think we need to hear the motion again.
Yes,
Okay. The thought behind my motion is that there were 2 bases for appeals. One is that the planning board simply accepted the applicant's characterization of the use without making their own decision, which we've already decided is not the case. And second of all, that the proper characterization of the use is other than what the board found. And thus, I'm responding to those 2 points. That is, I move that the zoning board of appeals deny this appeal on the basis that, 1, the planning board did not consider the proper use characterization of this project, because they did. And 2, they did not make an error of law, abuse its discretion, or make a finding not supported by substantial evidence in the record in finding that residential multifamily and office professional are the proper uses of this project, which are permitted in District 907.
I think you need all the language, Jeff.
okay,
Okay,
great.
okay, I'll buy that.
So it survives discussion. And I have to say, we were very lucky to have Bob as our
Yes.
colleague here to help us with these things. Any other discussion on the motion? Seeing none, I'm hearing somebody's phone.
Yes.
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 Yes,
Yes.
Yes,
600. I believe that concludes our meeting. Anyone want to call for adjournment?
So moved.
Before
Yep.
we adjourn, there's nothing really official, but we do need to think about, these findings of facts, getting those documented, and then meeting again to approve those. So when do we want to meet again?
How soon will the paperwork be done?
I leave tomorrow, I'm out of town, but I'll work on it periodically. This wasn't a very long meeting, so it shouldn't take very long. So theoretically, I can have it done in a week-ish.
can
We've done
we,
a few
can,
days.
can then you be sending those to us, we read it, and then have a quick Zoom meeting?
Yeah,
To
it can be a
accept
Zoom
them and
meeting. You
approve
have a
them, or do we
policy to
need
meet
another-
remotely.
Public forum like this?
You do not need another public forum. We can meet either in person or we can meet remotely.
I would vote for meeting remotely,
So I guess here's something that we can do. I can get it all ready, the document, and then let everybody know, let Jeff and Bob know. And then they can reach out to everybody,
We'll send
find a
out,
date
yeah.
that works, and
Mm.
then we, notify the public that that's
Okay.
when we'll be
Notify
doing
the
it for our
public,
next meeting.
yeah.
Well, what do we need for notification? Is it 7
It's
days?
just 7 days.
Okay. Yep.
Okay.
So we'll be contacting you guys for our next exciting meeting, which will be two-dimensional.
Exciting?
Okay.
Exciting?
Exciting, yeah, yeah.
Want to make sure.
I believe I would put that in.